Hi, my name is Amy Rich, and I work in the Outreach and Education Department at Texas Department of Insurance, Division of Workers' Compensation. Welcome to the 2020 Educational Series. The topic I'm going to discuss is Return to Work and the Work Status Report, also known as the DWC Form-073. The concepts I'll be discussing today apply both to your patients that are subject to non-network workers' compensation, as well as those patients we also call injured employees or claimants that have a claim that is subject to a workers' compensation certified network. So the concepts truly are both for network and non-network. And when we use the term return to work, we also mean stay at work or working in some capacity during their recovery. Both the Texas Labor Code in 413.011, which applies both to network and non-network, primarily non-network, and the Texas Insurance Code in the Section 1305, which mostly applies to the Certified Workers' Compensation Network, they both address the importance of preventing chronic disability or delayed recovery by promoting appropriate health care at the earliest opportunity after an injury or illness to basically maximize the healing and improve the stay at work or return to work outcomes for workers' compensation patients. Each of the networks, speaking of networks, are required to adopt return to work guidelines and require the treating doctor to participate in a return to work planning, the same as non-network. And each network is required to have quality improvement program that includes return to work programs. So both on the non-network and network side, we're all focusing in on the injured employees' return to work outcomes. Most workers' compensation injuries are temporary in nature, and we want to prevent chronic disability, and sometimes medically unnecessary time away from work results in delayed recovery or chronic disability. We'll start out with a disclaimer that this presentation today is for educational purposes only, and it provides general information. It's not a substitute for the rules in the statute, so if there ever was a dispute over something involving some of our guidelines of return to work, we will use the statutes and rules to resolve that dispute. And we expect the system participants to understand and comply with the sections of the Insurance Code and the Texas Labor Code and our rules, which are also called the Texas Administrative Code. The things we'll cover today are the goals and legislative intent for and addressing return to work, the medical literature that advocates for early return to work and working through recovery, and specifically the treating doctor's role and the healthcare provider's role in promoting and encouraging and facilitating return to work. Also the referral doctors and ancillary providers' role. All the healthcare providers taking care of our injured employees are responsible for encouraging, promoting, and facilitating return to work. And also we'll get into the completion of the work status report itself. Going over the goals or the legislative intent, the Texas legislature passed our laws, and the state agencies write the rules that support the laws. And in that law, it says the basic goal of the Texas workers' compensation system is to facilitate the injured employee, your patient's return to employment as soon as it's considered safe and appropriate by the employee's healthcare provider. That would be you, the healthcare providers. We rely on your medical opinion on when it's safe and appropriate to return the employee to their employment. So the longer the injured employee is away from work, the worse the impact of the injury. There is evidence that shows an employee who misses over 12 weeks of work only has a 50-50 chance of returning to their pre-injury productive work. So that's really important to remember, that keeping someone off of work when it's not medically necessary does impact their lives, and we want to keep them as functioning as high as we can, that's medically safe as soon as possible, and that includes recovering at work. Also to remember that return to work is a responsibility shared by all system participants. That includes the Division of Workers' Compensation, thus the education on return to work, the insurance carriers, and the healthcare providers. All of you are responsible for encouraging, facilitating, and promoting return to work for your patients and for the injured employees. And it could be an illness also in the Texas workers' compensation system. The statute also says the workers' compensation system must encourage safe and timely return of those patients to productive roles in the workplace. And that involves providing timely and appropriate and high-quality medical care so that you can help them restore their function, their physical condition, their earning capacity can be addressed by returning them back to work. The Division of Workers' Compensation has structure that supports those goals, and that structure can be found in our medical policies and guidelines. We have treatment guidelines that is evidence-based medicine. It is presumed to be medically necessary when you're following the recommendations of the treatment guidelines. All system participants should be following the treatment guidelines. On the non-network side, we use the official disability guideline, ODG. On the return to work guidelines, we use the MD guidelines. On the network side, the Certified Workers' Compensation Networks shall adopt treatment guidelines and return to work guidelines, and they can be different from the ones applying to non-network, which is ODG and the MD guidelines. But we understand that most of the networks may use the same guidelines that the non-network claimants use. So treatment guidelines, ODG, return to work guidelines, MD guidelines. Employer return to work programs is also part of that structure. We expect the employers of Texas that are subscribers to have some sort of return to work program. We do a lot of education to the employers to participate. They are in charge of making the employment decisions. The healthcare providers are in charge of addressing the medical necessity of restrictions or work status of that injured employee. And also, the division has rules and statute that support case management, and that's a collaborative approach of encouraging, facilitating return to work. If you're a healthcare provider out there, know that the insurance carrier could, at a certain point in time, assign a case manager to help facilitate the health care that the injured employee is receiving and the return to work goals. If they've perhaps surpassed some of the duration expectancies in the return to work guidelines. One thing to remember is the guidelines are just that. They are not absolute values. So if the return to work guidelines have a number of days that a medium heavy work status should return to work after a back injury, maybe it's 9 days, maybe it's 7 days, just depending on the situation. That is not an absolute value of when they have to go back or that they can return to work earlier than that 7 days. It's just a point in time that you should reevaluate your patient and where they are in respect to the return to work. There is medical literature out there that we've studied and that exists that advocate for returning to work as soon as medically safe. Now, I do have to say that we understand that there are injured employees that may not be able to return to work at times. We are not talking about that. We're talking about those injured employees that are taken off work that isn't medically necessary. A lot of factors play into the reasons why they're not being released to go back to work, and we want to try to address those in this presentation. But the medical literature we've reviewed comes from the American College of Occupational and Environmental Medicine. They have a position paper on the physician's role of encouraging and facilitating return to work and preventing chronic disability. The International Association of Industrial Accident Boards and Commissions, the American Medical Association, the American Academy of Orthopedic Surgeons, and more. There are numerous articles and studies that show that early return to work is beneficial for the injured employee, and you can be seen as advocating for the injured employee by getting them back into function, back to their lives, and back to their work as soon as medically possible, because if the longer they're off work, the more likely chronic disability can set in. And a large number of people who, due to their medical condition that should normally result in only a few days of work absence, end up withdrawing from work, either permanently or a prolonged period. That's what ACOM says in their position statement. All of these literatures and studies support preventing long-term disability and returning the injured employee to function as soon as possible in their care. The benefits for returning to work and recovering while at work is that they will recover faster. The more activity that someone has in their life, the more function, the faster they're going to recover. It can prevent deconditioning. So if someone's at home not getting out, their body can decondition and not be used to the activities, so the worse they can feel. Also, the psychological and social dysfunction that goes along with being isolated at home and not engaged in their lives and in the workplace, that can be exacerbated. Also, if they're off of work and it's not medically necessary, they're not going to retain the job skills. We know that things change in the environment at work a lot, and if they are off work, they're going to miss that activity. Their job skills are just going to be reduced if they're at home and isolated. Also, it is a potential that they could lose their job. These employers have to replace somebody. The work must go on. So if they're out of sight, they're out of mind, perhaps with the employer, and the sooner that you can release them back to some sort of modified duty or maybe even on a part-time basis, they're more likely to keep their job. The consequences can be dire for medically unnecessary lost time. They can have poor mental and physical health while they're off of work. The financial hardship can play into their lives. They're only receiving income benefits at 70% of their average weekly wage. That can impact a family or a person's well-being, and it could spiral and get worse, their financial as well as their mental and physical condition. It can cause issues with the family, the social isolation. Perhaps they had comorbid conditions prior to their injury. That could get worse. Diabetes, all of that. Mental illness can get worse. They can lose that connection with their employer. The social connection is super important, and the purpose of being at their job and the sense of purpose that they lose by being at home can impact their well-being. They're going to lose perhaps job-related benefits, maybe their Medicare, Social Security, their group health. That could be a loss for them ultimately, too, in a chronic disability situation. And they could lose their jobs. Now, employers may not fire someone just because they got injured on the job, but they may ultimately need to replace that position. Again, you as the healthcare provider are in charge of making a medical decision about what's safe for them to return to work and what's not, when they need perhaps a modified work environment when they return to work. So in fulfilling your role as a healthcare provider, treating doctor, establishing return to work expectations with the injured employee needs to be communicated during the first visit. It needs to be early and often. This will head off bargaining later. So if you're taking someone off work and it's not medically necessary and a certain time passes, it's harder to address with the injured employee when you're talking to them when they've been off work for a long period of time. So if you talk about it in the first visit and discussed often with every examination, talk about your expectations. They're going to look to you as a healthcare provider. They're going to take your lead. So it's important to have an open discussion with them about what you expect. Put their injury in perspective for them. Talk about what their recovery might look like, and that perhaps pain doesn't always mean that they can't be at work. We also want you to communicate regularly with referral and ancillary healthcare providers. Perhaps they're receiving physical therapy somewhere. Those physical therapists are spending lots of time with your injured employee and your patient. Those people need to speak about return to work also and return to function. That should be part of your treatment plan. So incorporate working into your treatment plan, and part of your prescriptions perhaps would be recover while at work. That will keep them ultimately healthier and recover faster. We understand that there could be non-medical factors that may interfere with successful treatment and return to work. The healthcare providers, if they're aware of this and work through that with the injured employee, that could help with a successful return to work outcome. Encourage the injured employee to participate in their recovery and talk to them about what they think they can do back in the workplace. Empowering the patient, your injured employee, to participate in their recovery and what they can do back at the job puts them in the driver's seat. This is a loss of control for them to be injured or ill from their occupation. So if you give them part of that and talk to them about it, include them in that, and listen to what they have to say, that will help them in their recovery. And explain to them that pain doesn't always mean further harm. It doesn't mean that they can't be active and working while they have pain. The treating doctor's role also is to assess the injured employee's abilities in relation to their functions and duties, not just the job description. So maybe they can be doing something else at their workplace, and that can be determined by talking to the injured employee about what they do at work, or the employer. We do encourage the healthcare providers to talk to the employers. This should be a collaborative process, and if everybody understands how detrimental it is for someone to stay off work when it's not medically necessary, I think more people would participate in the encouragement and facilitation of someone returning to the workplace. So be positive, identify what they can do, talk to the employer about options for restricted and modified duty assignments. Then you're going to specify their abilities, the injured employee's abilities, on the DWC Form-073. That's your communication tool, the form that we require you to fill out. Don't wait till the injured employee is 100% better or at maximum medical improvement, we call that MMI, before releasing them to work. They can work through their recovery in some instances. So those are the times we're wanting you to pay attention to what's medically safe for them and what they can do at the workplace. And release the injured employee to work as soon as it's medically appropriate. So what if the employer does not have a job for the injured employee to do? Well, first of all, you should not keep someone off work just because of that reason. The employer is in charge of making employment decisions, but we expect the healthcare providers to tell us and tell the system and tell the injured employee what's medically safe for them and what's not. And understand that even if the employer doesn't have a job for them, it does not impact the eligibility for income benefits for that injured employee. They're still entitled to their temporary income benefits to compensate for lost wages until they reach the maximum medical improvement. Temporary income benefits, or TIBs, are adjusted to match fluctuations in their earnings. So if you release them for a part-time basis, those average weekly wage and temporary income benefits are going to be adjusted. So don't include that in your factor and your determination of whether someone can return to work. You're deciding that with the help of the injured employee of what they can and can't do. You're assessing their risk and their capacity and their tolerance for going back to do something in the workplace. It is better for them overall to improve their function and include working through recovery. The referral doctors and ancillary healthcare providers, say physical therapists or other specialists that are involved in the care for this injured employee, collaborating with the treating doctor will help facilitate the return to work goals. We don't want to have one doctor saying one thing and another doctor saying another. If you speak to each other and maybe resolve some of those conflicts about when they expect the injured employee to safely return to some sort of work, try to get on the same page, because the injured employee may want to go with one DWC 73 work status outcome versus another. So if you coordinate between the parties, that is better for everyone. And the referral doctor is responsible for submitting a 73 also. So we don't want conflicting 73s here. So try to collaborate and communicate with the referral providers. The 73, it is the communication tool used to inform all system participants. So it's going to go to the insurance carrier, to the subscribing employer, and to the injured employee at the time of the exam. And it's going to communicate their functional abilities and whether or not they're able to work with restrictions or is unable to work at all. So when is the Form 73 submitted? For the treating doctor or referral doctor, it is on the very first visit. This does not include emergency room visits, but any doctor seeing a workers' compensation patient for the first time should be filling out a DWC 73. If these two doctors have delegated authority to delegate to a physician assistant or an advanced practice registered nurse, they are able to complete and sign the work status report, the DWC 73. So you fill it out on the first visit, and then after that, only when activity restrictions substantially change or their work status changes. So it's not on every visit, every exam, only on the first one. And if something changes from the first 73 on the next exam, then it would be required to fill out another 73. There is a situation where the insurance carrier can request a 73 from you, but it must be based on your scheduled appointments with that patient and not more than once every 2 weeks. So those are the three conditions the Rule 129.5 outlined for healthcare providers as it relates to when you're supposed to submit a 73. First visit, when anything changes, and at the request of an insurance carrier, not on every visit. If you're billing for the 73, if you're following along with these conditions, then reimbursement should be allowed for that. What is work status? And that is a term that refers to whether the injured employee, their medical condition allows them to return to work without restrictions. Maybe they have a small laceration, they can return to work immediately. This is not the same thing as maximum medical improvement. Maximum medical improvement means that they're as good as they're going to get medically. They've recovered at a reasonable probability. They won't get better from that point on. So MMI is different from releasing them to work without restrictions. Allows the injured employee to return to work with restrictions. Maybe you're going to release them for a part-time basis, or maybe at a lower lifting capacity, or some other types of restrictions, no kneeling, no standing, no climbing, that sort of thing. So they're able to return to work, but you have some modifications. And the last option on the work status report is preventing the injured employee from returning to work at all. So documentation is required when you make that decision to prevent someone from going back to work because it's medically unsafe. Also, a substantial change in activity restrictions. That means that they're able to do either more or less than the last time you assessed them. They've either improved or maybe they've gotten worse. So if something happens that changes, their medical condition changes enough to substantiate a change in their activity restrictions, then a 73 would be warranted on that visit. Who gets the form after you complete it? That is the injured employee at the time of the examination. And you can give that by hand to the injured employee. I would guess that this is the best time to have that discussion with the injured employee is while you're completing this form and talking to them about the restrictions, or that you're releasing them to work, or you're taking them off work completely. Talk to them about the duration. The MD guidelines are great at providing duration lengths. That may be something that you can lean upon when you're discussing with the injured employee, but this is a great time for the communication to occur. The employer gets a copy of that, and not later than the end of the second working day after that examination. And you can send it by electronic means also. The insurance carrier is going to get a copy from you, the healthcare provider, and not later than the end of the second working day after the examination. And you can send that by electronic means also. Let's get into talking about completing the DWC Form-073, which is the work status report. This is a screenshot of the top of the form. This is also an example of an employee that's able to return to work without restrictions. So maybe it's a minor injury. You're still going to fill out a 73, even if it's a minor injury. So the top part of the form is demographic information. And you'll notice in box 5A and 5B have been adjusted to accommodate the PA and APRN's ability to complete the form. You'll need to put your delegating doctor and their name in box 5A, but your name would go in, if you're a mid-level, in 5B. In box 4, I wanted to point out that this is your patient's words, your patient's explanation of the injury or accident or the illness. So that's what goes in box 4. In the section 2 is where you're making a decision about work status. 13A is you're releasing without restrictions, to the workplace without restrictions. So you'll put your X or check in that box, and then without restrictions and a date that they can return to work without restrictions. That's the top part of the form. And this is the top part of the form also, but it's an example where the injured employee is able to return to work with restrictions. So it's 13B that shows that a date and time that they're going to have restrictions, a to and from date. Again, the same information, the demographics in the part 1, and then part 2, 13B shows that you're going to release them to work with restrictions. The section of part 3 includes the activity restrictions. So you're going to look through here and check the boxes that apply for this injured employee to return to work with restrictions. And there is, in box 16, some open text that you can help explain the restrictions and modifications to the employer and to the injured employee. Here is an example of a work status report where the injured employee has been taken off work completely. So they have checked in part 2, 13C, and they have a date and they have an explanation of why the injured employee cannot return to work in any capacity. This is a pretty good explanation of why they can't return to work. This might cause injury, further injury, or risk to others in the workplace. Here is an example of that same scenario where the healthcare providers decided that the injured employee cannot return to work at all. And in 13C, they've checked it, and their explanation says pain. Well, we put an arrow in there and an editorial note that says that's not a sufficient explanation. It is true that some of our injured employees are in extreme pain, but we need more explanation of why they cannot return to work at all. Pain is not a sufficient explanation. So please give us more on the form to communicate to all system participants why they can't return to work at all, and to the injured employee. Sometimes it's justified. You just need to explain that in this form and also in your documentation of your office visit notes. The very bottom part of the form is your name and information and what visit it is, visit type, initial or follow-up, and your role as the healthcare practitioner. And in box 21, just a narrative description, general description of the condition that they suffer from, the accident. This is the bottom part of your form. And just to point out, APRNs and physician assistants, as well as the treating referral doctors, can sign this form now. The resource for doctors to make return to work decisions. For non-network, the MD guidelines I talked about earlier in the presentation are the adopted return to work guidelines for non-network. And on the network side, the certified workers' compensation networks can adopt their own treatment guidelines. So please check your contracts with the networks that you operate with to see which return to work guidelines they use. This is a product that's online that you can purchase for your office, and it gives duration, disability, lengths of time by job classification and type of injury. So it's fairly informative to the injured employee and to the doctor to give them points in time to reevaluate the return to work goals. It's not a prescribed set of days. It's not absolute value. So they could return to work earlier than it says or later than it says. It's going to give you minimum, optimum, and maximum duration disabilities for injuries and their particular job. It is a great tool and resource for doctors to lean upon when they're discussing with the injured employees expected return to work lengths. If you're an injured employee, perhaps they've lost their job, or perhaps they can't continue to do the job that they were in at the time of their injury or accident or illness, there is a state agency called the Texas Workforce Commission. They have a special department called the Vocational Rehab Services. They will provide services to eligible adults with disabilities, and that includes injured employees, to help them prepare for, obtain, retain, or advance employment. So they're going to help them with their resumes, maybe developing new skills, maybe helping them look for a job. So here's the contact information that you can give to your patients or injured employees so that they can contact the vocational rehab department. We also, as a state agency, refer injured employees to this state agency also. So it's there as a resource. Understand that it's there, and have the injured employees call if they need help returning to the workforce. And why is return to work and this whole concept important to you, the treating doctors and mid-levels and referral doctors? First of all, you may experience better return to work outcomes if you understand how detrimental it is for someone to stay off work when it's not medically necessary. Also, the Division of Workers' Compensation has a program called Performance-Based Oversight. You may know it as PBO. And we do look at and monitor the completeness of the DWC Form-073, the work status report. So we'll do samplings and look at what the doctors are placing there, or the PAs or the APRNs are writing in there. And we're also looking at your documentation that supports when you take a patient off work completely. That is really important to us because we as a system need to help prevent chronic disability and delayed recovery in the Texas workers' compensation system. And staying off work when it's not medically necessary, it's more likely to have and promote delayed recovery and promote chronic disability. Lastly, you have the Division of Workers' Compensation resources. If your doctor has further questions about return to work, you can call Comp Connection. If you have questions about the Form 73 and who it goes to and how many days you have to get it there, questions about how to fill it out, you can call the 800 line, option number 3, and the local number. Or you can email us at medbin@tdi.texas.gov, or our website has return to work information on it. Go to your topics A through Z and select disability management or return to work services. We have information there. Our role as the Division of Workers' Compensation is to monitor compliance also. If you suspect that some system participant is not complying with our rules and statute, you may file a complaint with us. And there are many ways to file a complaint. You can email it, fax it, take it in person, or mail it. And here is the link to file a complaint. Please let us know. That is the last slide for this presentation. I want to thank you for participating and logging in to hear our presentation. Thank you for your time.